Tori Music versus Nathan Ellison.
For the record, this matter is before the court on the plaintiff's motion to modify parenting time and other relief. This hearing is being conducted via Zoom. President Attorney Alexis Spencer representing the plaintiff petitioner, Tori Music. Ms. Music appears to be present with Ms. Spencer. Good morning, Ms. Spencer.
Good morning, Your Honor.
In addition, the defendant, Father Nathan Ellison, is also present. Good morning, everyone.
Good morning.
Parties have conferred with Ms. Brower for the front of the court this morning. The court has received the following recommendation: that father's parenting time be modified to every Monday and Wednesday from 6 to 8 p.m. In addition, father shall have every other Friday, 6 p.m. Actually, every other weekend. Fridays at 6 p.m. till Sundays at 6 p.m. Summer parenting time should be week on, week off. It's further recommended that neither party shall discuss this case with the minor children. Neither party shall consume alcohol or drugs, including marijuana, prior to or during their parenting time. Parties shall communicate via app close. Sister Rachel Marr shall not be present during the defendant's father's parenting time or babysit the children. Neither party shall use inappropriate language in the presence of the children or allow the children to use curse words. Parents should discourage that, obviously. And finally, there should be no disparaging remarks by one parent relative to the other parent in front of the minor children. That is a recommendation. Ms. Spencer, is this recommendation agreeable with your client this morning?
Your Honor, we do agree with everything in the recommendation, but for the parenting time, we are just requesting that his parenting time be bumped up, either on the Monday and Wednesday from 5 to 7, due to the children being 5 and 7 and getting home. Even though his parenting time currently that he's been exercising has been until 8 p.m., he actually doesn't even get the children home until after 8. I think he believes that the order means he gets to leave his house at 8 o'clock, which obviously is not the case. But we are just requesting that it be modified to be 2 hours earlier so that the children are not getting home and too tired to, get bathed, to get ready for bed, do any extra homework they might need to get finished, because that has been an issue. The defendant stated that his work schedule doesn't allow for that on Mondays and Wednesdays, but he did state that he, at a different point, was off on Mondays and Tuesdays, and his work was an issue from Wednesday to Sunday. So don't really know what his actual schedule is, but regardless, it's not in the kid's best interest. And he thinks that because it's not in his best interest, that it doesn't work with his, other priorities or whatever he might have, that should be the reason that it stays from 6 to 8. So we're just requesting not that any parenting time be taken away, just that it be moved up 2 hours.
So you're suggesting 4 to 6 rather than 6 to 8?
Sorry, no, we're requesting that it's from 5 to 7. So I meant the 2 hours just moved up to 1 hour.
1 hour.
Sorry.
All right.
Yeah.
So 5 to 7 rather than 6 to 8.
Correct.
All right.
I can't hear anything. You guys are cutting out.
The children, what time do the children go to bed?
Well, when they
Yeah,
get
4 to
home
7-year-old.
when they get home from his house, they're not getting to bed until 9 at the earliest, which obviously, again, is pretty late for a 5 and a 7-year-old on a school night.
What time do they go to bed at mom's home when it's mom's nights?
I like to have them in bed at 8 o'clock and sleeping by 8:30.
Okay. What's the distance, the travel distance between mom and dad's home?
25 minutes?
25 minutes.
All right.
12 miles. 12 miles.
Hold on, sir. Mr. Ellison, hold on. Let me just ask you, I'll give you an opportunity to talk. So when it's dad's parenting time, the children don't get to mom's home till about 8:30, is that correct?
Correct, because he's not actually leaving to be able to get them home at 8.
Okay. Obviously, children need some wind down time before bed. All right, Mr. Ellison, do you understand the recommendation this morning?
Say that again. You're cutting out. I can't hear anything.
Okay. Why don't you sit down, Mr. Ellison, rather than walk around? Why don't you sit down, get situated so we can have a discussion, please?
I'm trying to find a spot where I can have service, and I couldn't hear anything you guys said.
Okay, do you understand the recommendation this morning, Mr. Ellison?
I work 6 to 6 every single
Mr.
day.
Ellison,
Yes.
Mr. Ellison, hold on. I read the recommendation. Do you understand the recommendation, first of all?
Yes, I do.
Okay. Obviously, everything's agreeable with Ms. Music other than the time on Mondays and Wednesdays. Do you have any objection to the recommendation this morning?
Yeah, I work. My schedule is 6 to 6, Monday through Sunday. I work in the auto industry. Some days I get off at 4:30. Some days I get off at 6. It all depends on how hard we work and if we hit our number. towards the end of the week, it gets longer because we don't hit our number. You know, Monday I could get off at 4:30. Tuesday I could get off at 4:30, but everything changes after that. It's always been like this. She knows this. It's hard for me to get to my kids at 6 a lot of the times. I'm usually 10 minutes late, 15 minutes late sometimes, because it takes me 45 minutes from work.
Mr. Ellison, what is your objection to the recommendation?
Mine that 5 o'clock, I can't get to my kids at 5 on those 2 days.
Recommendation, sir. The recommendation, Mr. Ellison, is Monday, Wednesday, 6 to 8. What's your objection to that?
Oh, I'm fine with that. I thought it was, she just said it was 5 to
Come on,
7.
Mr. Ellison, pay attention. The question is, do you understand the recommendation and do you have any objections to it?
Yeah, because I said I couldn't hear you. That's why I moved.
Do you understand the recommendation, Mr. Ellison? Do you want me to read it again?
Please.
Okay, the recommendation of Ms. Brower this morning after I've talked with you is that if the court adopts the recommendation, it'll become order of the court. The recommendation is that father's parenting time will be every Monday and Wednesday, 6 p.m. to 8 p.m. In addition, fathers shall have every other weekend, Friday at 6 p.m. to Sunday at 6 p.m. Some parenting time should be week on, week off. It's further recommended that neither party shall discuss this case with the children. All communication between the parents shall be via app close, which is an app you put in your phone. Neither party shall consume alcohol or drugs, including marijuana, prior to or during parenting time. Your sister, Rachel Marshall, will not be present during your parenting time or babysit the children. Neither of you should use any make any disparaging remarks about the other parent in the presence of the children. Neither party shall use inappropriate language in the presence of the children or allow them to use curse words. That is a recommendation. So let me go back to the original question. Do you understand the recommendation?
Yes.
Do you have any objection to the court adopting this recommendation?
Say that again, you're cutting out.
Do you have any objection to the court adopting this recommendation?
Yes. The not letting my sister babysit. I don't like that my sister can't help me. That's my family. I need help.
Well, this is parenting. This is your parenting time, not your sister's parenting time or your grandparents. This is your parenting time.
Correct, but during the summer when I do 7 on, 7 off, I need a babysitter to help watch my kids. My sister helps me because my parents can't do it 7 days a week. My parents are in their 70s.
All right, but you still want the 6 to 8 on Mondays and Wednesdays, correct?
Correct.
Schedule. Now, what about to suggest that you're off work on Mondays and Tuesdays? Is that correct or not?
That is not correct. I was stating that my schedule is different on Monday and Tuesdays than it is the rest of the week. Like I get off this week at 6, but last week I got off at 6, and this week I got off at 4:30.
Is it better with your work schedule to do parenting time on Mondays and Tuesdays rather than Mondays and Wednesdays?
No, because it could be different any week. You know, I could be scheduled to 6 next week. I could be scheduled 6 every day. You know, it all just changes. We're in the auto industry.
And you can get the children back to mom no later than 8:25 or 8:30, correct?
Correct.
Right. It's very important. Obviously, children, they're young. They need to get to mom's home and they need to unwind. There's no immediately go to school. And when they leave your home, do they have their pajamas on?
No. Sometimes yes, but not all the time.
Maybe that's what you do. Maybe mom sends the children with their pajamas. Dad has them bathed in their pajamas when they're dropped off.
I only get 2 hours a night, sir. I've done that. I read with my son, and then sometimes we will shower if we have time. You know, I do.
You gotta make time. You gotta make time. This is the time to unwind.
If I had more time, I could make more time. You know, 2 hours isn't enough.
Well, are you reading to them?
I
What
do.
do you
Yes.
do during 2 hours? Do you, they've already, by the time they get you're home, they've already had dinner, correct?
Sometimes it all depends. They want to sometimes eat with me. Sometimes they want to eat at home.
Okay.
But yeah, we make sure they are well taken care of. You know.
I understand. I'm trying to understand what you typically do during the 2 hours with the children on Mondays and Wednesdays. What's your typical 2 hour look like?
If it's nice out like it has been, we usually are outside running around, playing basketball, soccer, you know, come in, unwind, eat, read. and then get ready to go, you know, because our time's up.
Well, obviously, as the children get older, these weekdays are going to be more problematic because they need to be in a consistent schedule. So let's go with the issue about the sister, Rachel. What's Ms. Spencer? What's your client's concern about Rachel being the presence of the children?
Well, Your Honor, in the motion, I stated that there's issues with the sister allowing them to cuss, or cussing in front of them, allowing them to cuss. His sister's children are also young, and the children have made inappropriate comments to their children that they're clearly learning somewhere. One of which, for example, was his niece stated to their daughter, who was 4 at the time, that she was going to suck her brothers, which is obviously very inappropriate. I don't know where she would have heard that, but during the friend of the court part of this proceeding, he also informed us, I think 2 times, that his sister doesn't allow them to cuss and actually puts soap in their mouth when they cuss, which is also inappropriate. And my client wasn't even aware of that, but she does not approve of that. So that is another issue.
Okay. Okay, what's your response to those concerns, Mr. Ellison? Mr. Ellison, what is your response to those concerns?
I can hear you now.
Okay, what is your response to those concerns about your sister?
I don't know. I've never heard my niece talk like that. And if my sister's babysitting the kids and they're doing something wrong, she's not allowed to discipline them. She's the adult in the room, right? And
she's not a parent. She's not a parent. She has no right to discipline your children.
Okay, so they're just supposed to be wild with her then? I'm not saying she did. I'm not saying she did put the soap in their mouths. She told me she would if they were cussing in front of them.
That is not what he stated.
Right.
That's exactly what I said.
All right, the court has confidence in Ms. Brower and the recommendation. The court this morning will adopt the recommendation. So the period of time, the time frames will continue Monday to Wednesday, 6 to 8. The court would indicate to Ms. Music and Mr. Ellison, as the children get older and more active in school, they need more of a set schedule. So this may not be their best interest as we continue as they get older. It's disruptive to have the school week parenting time like this. But for the time being, the court will continue parenting time 6 to 8, alternate weekends, 6 to on Fridays, 6 to on Sunday, week on, week off parenting time during the summer. And Mr. Ellison, your daughter Rachel should not be present during your parenting time or babysit the children. So you need to find if you're not there and your work schedule is such that you tell Miss Music that you can't exercise your parenting time. So you need to find another third party, your parents or someone else other than your sister.
My parents are awful old, sir. They can't do it 7 days a week.
All right. If you can find someone else, then you'll just have to tell Miss Music that you're not available to exercise your parenting time. But at this point, the court's going to adopt Ms. Brower's recommendation. And that will conclude this hearing. You can zoom out. Have a good rest of the day.
Thank you, Your Honor.
You're welcome. Thank you, Ms. Brower. You've been mailed a copy of this order, Mr. Ellison.
What's that, sir?
You've been mailed a copy of this order.
Okay, thank you. Have a great day.
Nancy's help.
Thank you. Good morning, Ms. Patrick.
Okay, so in the case I've got, Nancy, it's Megan Osmus versus Victor Solo. Now
Yes.
he's saying he filed a motion for custody. So she's got one for parenting time in custody. He's withholding the children. I told him he's got to give her the children back today. But I want to adjourn all these motions to the same date. So do you have a date for his motion? He said he turned it in yesterday. Whatever the court would. CPS is involved. He's been holding the kids since February, blah, blah, blah. So.
Okay, so we'll get a rec then he shall immediately return the children to her.
Yes, and then he's got every weekend from Friday till Monday back to school.
But how long is he denied parenting time?
It sounds like it was sometime in February, although she admits she called him to come get the children. So I think we should just adjourn everything and we'll sort it out at the next date.
Okay. I'm just wondering, for example, his parenting time is every weekend, Friday at 5. So do we give her this weekend, start his parenting time back maybe a week from Friday?
Well, I'm hesitant to do that, Your Honor, because
Okay, all right.
she looks a little, we'll talk about it in a minute. I told him to give her the children at 5 o'clock today. And then
Okay.
he gets it back on Friday.
Okay.
Okay.
All right, I do have an opening on May 8th. Is that too soon at 1:30?
May 8th will work. So did you say May 8th, Nancy?
May 8th, that's a
Okay.
Wednesday.
You would need to make a note, Nancy, that somewhere down in the clerk's office, he filed a motion to change custody.
Okay.
This will be
So
her
rather than
notice.
be set here, but rather than before
No,
referee.
yeah, absolutely. It needs to be said here. I'm sorry, Nancy, what time was that on the 8th?
Sure, at 1:30.
1:30?
You hear me?
And then I'll let her know this is her notice in case he can't get her served. Okay? Let me bring them out.
The children, are they in school?
No, not yet. They're not going until the fall. The oldest one just turned 5.
Okay. What about returning the children at noon today? Do we need to wait till 5 o'clock?
I would prefer 5 o'clock, Your Honor.
Okay, all right,
I'll explain at the end of the hearing.
okay, no problem. For the record, this matter is before the court on the plaintiff mother's objection to a referee recommended order which denied her motion regarding alleged denial of parenting time. Ms. Osmond failed to appear for that
Hang on,
referee
Your Honor.
hearing.
I'm sorry to interrupt. She's just logged herself out. Hang on, please.
Okay, for the record, this matter is before the court on the objection filed by the plaintiff mother, Megan Osmus, to a referee recommended order which denied her motion, complaining about denied parenting time. The court would note Ms. Osmus failed to appear for that hearing. Ms. Osmus, make sure the front of the court has your current mailing address.
Yes,
Okay. In any event, this hearing is being conducted via Zoom. It appears that Ms. Osmus is present as well. Defendant Father Victor Solo Jr. Good morning, both of you.
Morning.
You confer with Ms. Patrick. Ms. Patrick has provided the court with fine recommendation that referee recommended order be rescinded and canceled. There's also reference to a referee hearing of April 10th, 2024. Ms. Patrick, what's that about? Is that
Your
necessary to
Honor,
be part of this order?
Yes, Your Honor, just for efficiency, that one was heard in front of referee Hamrich, and she adjourned everything to this court for this date.
Okay, so that referee hearing April 10th will be
I would like it adopted and confirmed just so that it follows in the court file that's why we appeared in front of you today on the 24th.
okay. It's further recommended that the two parents will follow the current order regarding parenting time. My children will be returned to the plaintiff mother at 5 p.m. today at the Monroe Police Department. It's also noted that who's filed the motion to change custody? Is it mom or dad?
Both of them you
Both
have,
of us.
Your Honor. Mom has a motion to change parenting time and custody. Dad has informed me that he filed yesterday for a change of custody.
Okay. So it's further recommended. It's noted that plaintiff mother has filed a motion to change custody and parenting time. That will be heard by this court on May 8th, 2024 at 1:30 p.m. We'll also entertain at that time, Mr. Stoll, once you file that motion, your motion to address parenting time and custody will also be addressed at the same time, May 8th at 1:30 p.m. Now we via Zoom. So keep the court Zoom ID number. Ms. Osmus, if you don't have an iPhone, you can appear like you are this morning, go down in front of the court.
Okay.
Mr. Osmus, do you understand the recommendation this morning?
Yes, I do.
Okay, any objection to the court adopting this?
No.
Right, Mr. Solo, do you understand the recommendation?
I do, Your Honor.
Do you have any objection to the court adopting this recommendation?
I do not, Your Honor.
Okay, all right, so you'll return the children to mother, meet at the police department, Monroe Police Department at 5 o'clock tonight. Obviously, if you have CPS reports, other things, you need to produce those and provide those to the court for this May 8th hearing. Thank you, Ms. Patrick. The court will adopt the recommendation. We'll see everyone back on May 8th at 1:30. And please, Mr. Soul, make sure they're there at 5 o'clock today.
Yes, sir.
All
Yes,
right,
sir.
all right, now we'll conclude this hearing. You can both zoom out. Copy this will be mailed to each of you.
Thank you, Your Honor.
Thank you, Your Honor.
Welcome.
Thank you, Your Honor.
Clicking and rustling around. And
It was like that in the last mediation as well.
It still sounds staticky on my end.
it's really annoying. Now it's quiet. Maybe if you sit still, I don't know.
I don't know what the deal is.
Do you want to try and go outside and see if it's better? Oh, it's
It
still
might
kind
be
of,
this phone. I don't know.
it's no matter where you're at, it's a lot of noise.
I apologize. I don't know how I can fix it.
Do you think she should call her? Let me see if I take your video off, and sometimes that helps.
Osmus versus Victor Solo Jr.
For the record, the docket says this is plaintiff's motion.
It's her video.
Megan, can you change, we're gonna put you on audio only. We got too much background
okay.
noise.
Okay.
Do you want to give her the phone number and we'll take
Okay,
care
we'll
of it?
do this beforehand. No, let's do it.
No, it's-
Okay, for the record, this doc says this is plaintiff's motion to change parenting time, but I believe it's the defendant father's motion to modify parenting time. This hearing is being conducted via Zoom. It appears that both parties are present. So you're Victor Solo. Mr. Solo, you're the one that filed the motion, correct?
We both had complaints on this date, Your Honor.
I don't know about complaints. Who filed the motion? The doc says plaintiff's motion, but the motion I see is the father's motion.
Yes, sir.
Your Honor, there are competing motions right now. Mom filed hers
Yes, sir.
originally, and that was the
All right.
April 10th date that was in front of the referee. They objected, and then Dad also has one now scheduled for May 29th, I believe, in front of referee Hamrick.
Correct.
Okay. But we are both motions scheduled before referee Hamrick at the same time?
No, the one Mom's motion was heard on April 10th, and that's how they got the de novo. I believe that was done April 24th, just a couple weeks ago. That was
Correct.
Mom's motion. That was in front of Ms. Hamrick.
Okay, yeah, the court stands corrected. The parties did appear on April 24th. And the court adjourned the plaintiff mother's motion, to modify parenting time, change custody to today's date. So there was never a recommended, referee recommended order on her motion. Is that correct, Ms. Andrus?
Let me see. One on, no, April 10th, Ms. Hamrick did type up something. And it's still in the 21-day hold, so it's technically not an order yet.
All right. Well, did she issue a recommended order addressing it, or she just simply referred it to the court's docket?
She referred it to the court's docket.
All right.
docket.
All right. Unless parties have an agreement, the court's going to refer both of these to referee Hamrick on the same date and time. So then the referee can make a recommendation on each of the parties' respective motions, and if they disagree, then it'll come back before the court.
Please. 29th would be
Miss-
great, Your Honor.
Is that the date that referee Hamrick, the party's ready before Hamrick on the 29th? Is that correct?
Yes, at 9 a.m., sir.
Is that correct, Ms. Andrus?
Correct, Your Honor. May 29th at 9 a.m.
All right. If you can prepare an order for the court that the plaintiff and defendants' respective motions to modify parenting time shall be heard by referee Hamrick on the same date and time. May 29th at, I'm sorry, what time again, Mr. Solo?
9 p.m. I mean, 9 a.m., sir. I'm sorry.
9 a.m. All right, so
Yeah.
Ms. Osmus, you need to appear on May 29th at 9 a.m. on both your respective motions. And referee Hamrick will make a recommendation. If you disagree with that, then you'll come before this court to make final decision.
Your
And,
Honor, may I? Oh, sorry. Excuse me.
Yes, you're alleging that Ms. Osmus has unstable housing. Where do you currently reside, Ms. Osmus? What's your mailing address?
You need to unmute me.
It's B. That's Brownstown.
Is that the address you have on file, Ms. Andrus, for Ms. Osmus?
It is not. I informed her that she needed to update her address with us in writing.
Ms. Osmus, you need to come down in front of the court and change your address in writing because you're not going to get this notice.
Okay. Yeah.
She did not receive several notices because of the change of address.
I had originally, Your Honor, I originally had my mailing address at this address, and then it was swapped to my mom's for a short period, and I have just yet to change it back.
Okay, you need to come down today and change that address to get the copy of this notice, Ms. Osmus.
Your Honor,
Okay.
you missed 3 court dates because of the same excuse.
I was
Your Honor.
only aware of one, Your Honor.
Well, the court's obviously, that's a concern of the court, Mr. Solo, that there's unstable, as Ms. Osmond's
Yes,
moving from
sir.
place
Yes,
to
sir.
place. That's an issue.
Absolutely, Your Honor. Your Honor, may I say one thing, please?
Yes, Mr. Solo.
We went to court 2 weeks ago. You ordered me to return the children to Miss Osmus at 5 p.m. that day on Wednesday, and I returned the children. Miss Osmus told me I would never see my children again.
That did
And
not happen, Your Honor.
may I speak, please? And
Ms.
Your Honor,
Osmus, just let Mr. Solo finish, please.
Your Honor, on Friday, you ordered her to, as well as the referee ordered her to bring me the children back at 5 p.m. on the following Friday. And she did not. She has not brought the children back one time. I was supposed to have them 8 days since 2 weeks ago, and she's not had no contact with me. I have several CFS numbers. Nobody's contacted her. The CFS Brownstown Police went to where she says now is her address, and Mr. Osborne told him that she's never lived there. She does not live there and will never live there again. I have the CFS number report for that as well, Your Honor.
Okay. When did you last have the children, Mr. Solo?
On the day 2 weeks ago, when you ordered me to return them.
The last
Okay,
day we were
hold on, Miss
and he had been
Osmus.
holding my kids 3 months
Hold on, Miss
prior.
Osmus. We're gonna mute you, Miss Osmus. Please let the court ask questions. Mr. Solo has plenty of time every other weekend, correct?
Correct.
Yes, and
Every
I was
weekend,
ordered
sir.
to return them to him. I took my children on vacation after he held them from me for 3 months, Your Honor. I missed another birthday 2 years in a row because of him holding my children from me. So yes,
Okay, we're going back to
I
parenting
took
time.
them on vacation.
Miss Osmus, when are you gonna return the children, Mr. Solo?
Friday at 5 o'clock.
Your Honor, she did not return them the 2 weekends before since we went to court for the
Wait,
Friday,
Mr.
Saturday,
Solo?
Sunday,
I
Monday.
have not
Yes, sir.
Solo?
returned them.
Yes, sir.
Mr.
Yes, sir.
Solo?
Yes, sir.
Mr. Solo, Miss Osmus?
Yes, sir.
We can address, make up parenting time when we come back to court. But
Yes, sir.
Miss Osmus, Mr. Solo has the children after school on Friday or 4 o'clock, not 5 o'clock, but after school. So Mr. Solo, you should pick up the children from school. That's what you've been doing, correct?
We
No, sir, my
verbally
children.
agreed on 5 o'clock.
Miss Osmus, Miss Osmus,
Sir,
stop.
Your
Mute Miss
Honor, may I
Osmus,
speak?
please.
I'm
Just a
sorry.
minute. Yes, we got to mute Miss Osmus because she will not stop interrupting. Mr.
I'm
Solo, your
sorry.
parenting time, if the court understands correctly, the prior order of October 2023, you have alternate weekends, Friday after school or 4 p.m.
Correct.
Till Monday morning to school or 11 o'clock, correct?
Your Honor, we agreed to Friday at 5 p.m. till Monday at 5 p.m.
All right. You should be changing court orders because that's when you run into problems. Miss Osmus, would you agree?
Yes, yes, sir.
And the children will be available for Mr. Solo to pick up at 5 o'clock on Friday?
Yes.
Okay, where?
Monroe Police Station.
Please.
Okay, so you make that happen. Make it happen, Miss Osmus. Otherwise, you'll be held in contempt. You must follow this court order.
Told her the
Yes.
same thing 2 weeks ago.
All right, Mr.
The
Solo,
same
just
thing
make a
to you,
note,
Mr.
because
Solo.
if we need to, Mr. Solo, we can award you make-up parenting time if she's unreasonably denying you parenting time. We can address that.
Thank you, sir. Thank you, sir.
Right, so both of your respective motions are referred to the referee to deal with both of them on the same date and time. If you could put an order to that regard to Ms. Andrus. And Ms. Osmus, a copy of this order is being mailed to you at the address on file. So if you want a copy of this notice, you better come to the courthouse, need a copy, and make sure you change your mailing address.
Absolutely.
Thank you, Your Honor.
All right, thank you, Mr. Solo, for your patience and asking for permission to speak so we can have an orderly court proceeding. All right, that will conclude this matter. We'll see you in then probably a couple weeks then. But make sure you prepare for the referee on that day.
Absolutely, Your Honor.
Okay, you're all set.
Thank you.
Welcome.
Granted,
Page one,
that new
Ms.
record
Andrew Heiserman versus Denver Goon.
For the record, this matter is before the court on the defendant father's objection to a referee record order, which denied his motion to modify custody. It's also before the court on the defendant's amended motion for custody, filed by Attorney Kuhn on his behalf. This hearing is being conducted via Zoom. Present is Attorney Kimberly Kuhn, representing the defendant father, Denver Goon. Mr. Goon appears to be present with Ms. Kuhn. Good morning, Ms. Kuhn.
Good morning, Your Honor.
In addition, the plaintiff mother, Cassandra Heiserman, is also present. Good morning, Ms. Heiserman.
Good morning.
The parties have conferred with Ms. Brower from the front of the court this morning, who has provided the court with the following recommendation. That the parties shall, from this point forward, shall share joint legal custody which means the two of you should share equal any major decision concerning the welfare of your 6-year-old child, such as medical treatment. It's further recommended that father shall have extended parenting time effective immediately with the minor child, Carson. And mother shall have parenting time supervised by the maternal grandmother, Michelle Miller, on the days and times agreed upon by the parties. Issues of custody and parenting time are referred to the front of the court for a formal investigation recommendation, with each side having 21 days in which to object to any such recommendation. The minor child shall not be interviewed as part of this investigation. And finally, the parties will return back before this court to review custody and parenting time on June 18th, 2024 at 8:30 a.m. via Zoom. That is the recommendation. Ms. Kuhn, is your client agreeable with this recommendation this morning?
Yes, Your Honor.
Thank you. Ms. Heisman, do you understand the recommendation?
Yes.
And if adopted, it'll become an order of the court. Do you have any objection to the court adopting this recommendation?
No.
Okay. Obviously, we want, hopefully this is short term, we want you to address the issues that you're dealing with right now in terms of treatment counseling. And any updated reports you can provide will be very relevant. You can provide those to the front of the court and or this court on June 18th. You'll both receive information from the front of the court, written information that needs to be completed, and I believe there will be a phone interview with both of you from Ms. Scott from the front of the court. Anything further this morning, Ms. Goon?
No, Your Honor, thank you.
So the court would encourage Mr. Goon to work with and communicate with Ms. Heisman so that their 6-year-old child does have time with mom, just to make sure that the child, of course, is safe and protected.
You will do
Obviously, the
that.
child needs a relationship with both mom as well as with dad. So the court would encourage Mr. Goon to facilitate that between now and June 8th.
You will, Your Honor.
Okay, if there's nothing further, that will conclude this matter.
I have a question.
I'm sorry, go ahead, Ms. Eisman.
Yeah, I'm sorry. I have a question. I don't know what days now that he's going to get her, because we're not going to be able to agree on days that he's going to get her now. I would want that court ordered.
Well, this recommendation is that the dad has extended parenting time. So Carson will be with dad, and the time Carson will be with you will be a day's time to be agreed upon, and of course, got to be supervised by your by my mother. Your mother, Michelle Miller. So a lot of it depends on not only your schedule, but Miss Miller's schedule as well, when she's available to supervise this. So the three of you need to communicate in terms of when it's I know Carson is he in first grade, correct?
Kindergarten. Yep.
Or kindergarten, okay. So a lot of it depends on the availability of your work schedule of you and your mother. So I think you first want to reach out to maternal grandmother Michelle Miller, find out her schedule and when she's available to be present, at whether it's at her home or your home, to supervise your parenting time. And then you and Mr. Goon can communicate, and of course encourage Mr. Goon to make it reasonable and liberal. And we're going to come back and review all this in about 8 weeks.
Okay.
Any other questions, Ms. Eiserman?
No.
Any other questions, ma'am?
No.
Okay. All right. The court will adopt the recommendation to be mailed a copy of this. We'll see you on June 18th and at 8:30.
Okay.
Thank you, Ms. Brower.
You're welcome, Your Honor.
For the record, this matter is before the court on the defendant's motion to terminate a personal protection order entered back on October 13th, 2023. And this hearing is being conducted via Zoom. Present is Attorney Alex Goldman, representing the plaintiff petitioner, Aaron Hinckley. Ms. Hinckley is present. In addition, Attorney James Bartlett is present, representing the respondent, Paul Hinckley II. Mr. Hinckley is present with Mr. Bartlett. Good afternoon, everyone.
Good day.
Good afternoon.
So if I may, since it's our motion, I guess I'll try to be as concise as possible in regards to what I believe the agreement is. We had originally filed our motion to terminate this some time ago. Since then, there have been some developments. We are in agreement that the personal protection order remain in place with one modification. Presently, Mr. Hinckley is being directed to use third parties to transport the children for visitation. Ms. Hinckley has, and I'm not bad mouthing anybody, she's allowed to, she's not the subject of the PPO. She's gone to his home and dropped off the children, etc. So I believe we're in agreement to remove the third party requirement for transportation for the children and change that to curbside. She lives in an apartment complex. Mr. Hinckley does not have the desire nor need to go to her door. The children are old enough to be to get themselves from the curb to her apartment. So that's the modification that we're all in agreement on.
Thank you, Mr. Bartlett. Mr. Gomez, is that correct?
Yes, Your Honor.
There's also an underlying family court case, is that correct?
Yes, Your Honor. I believe there's a divorce.
Okay, well,
That was a long time ago.
what's the last order in that case provide for transportation of the child for parenting time purposes? Does it also have the same language requiring a third party to be utilized?
It did not.
Okay, so there's nothing in that family court case that has to be modified, just simply this provision in paragraph L of this PPO needs to be stricken from this PPO, is that correct?
Yes.
Or maybe modified to specify curbside exchanges. Well,
Either
or maybe
way.
not. You're right, because it's already, he's prevented from entering the property. So maybe
Correct.
it should just be stricken.
Okay, and it's noted that the exchange will be curbside. The child is old enough to get in and out of the vehicle, is that correct?
Yes.
Okay. Of course, the other option is, and I'll leave it to, I don't want to throw a wrench into this. The other option is to simply just terminate the PPO and enter into a mutual restraining order in the DM case with such provision.
That is not our preference, Your Honor.
Agreed.
Would that be cleaner than the DM case? Then it's all in the DM case and we can simply just close out this PPO?
That's not a request, but we do appreciate and take your recommendation or your proposal under advisement.
All right. So you want the court to then, I can print out another order and simply just modify the PPO to eliminate paragraph L requiring third party transportation, correct?
Yes, sir.
All right.
Yes,
all right, Mr. Do you want the parties sworn? Do you want to warn your respective clients, Mr. Bartlett? Mr.
Sure, might as
Bowman?
well. We're here.
All right, Mr. and Mrs. Hinckley, can you both please raise your right hand to be sworn, please? All right, Mr. Bartlett, you want to begin with
Sure.
Mr. Hinckley?
So, Mr. Hinckley, I know that you had retained me to help terminate this personal protection order some time ago, correct?
Yes.
All right. Since that time, there have been some developments that at this point, we're not seeking a complete termination, but we are seeking a modification, correct?
Yes.
All right. And you heard the modification terms that were placed on the record today, correct?
Yes.
And those are agreeable to you, correct?
Yes.
All right. Thank you. Nothing further.
Mr. Goldman, any questions, Mr. Hinckley?
No, Your Honor.
Questions for Ms. Hinckley?
Yes. Aaron, did we discuss the terms of the modification that were just read on the record?
Yes, we did.
Do you have any questions about that?
No, I don't.
And do you agree to modify the PPO along those terms?
I do agree to modify those.
Nothing further, Your Honor.
Mr. Bartlett, do you have any questions of Ms. Hinckley?
I do not. Thank you.
Very well. The court will enter such an order, modifying the personal protection order in this case. You know, it's a motion to terminate. We'll modify it to eliminate the requirement that third parties facilitate transportation. The parties shall do so themselves and simply it'll be a curbside drop off.
Thank you.
All right. Thank you, Mr. Bartlett. Mr. Goldman, probably facilitate ample resolution that appears most reasonable. The court would applaud Mr. Hinckley for reaching their own agreement. So with that, the parties can zoom out. Have a good rest of the afternoon.
Thank you, Your Honor.
Thank you, Your Honor.
Welcome.
Versus Michael Zarson.
For the record, this matter is before the court on the petitioner Angela Burns' motion for show cause alleging that the respondent Michael Zarzik has violated the personal protection order. This hearing is being conducted via Zoom, and you are Angela Burns, is that correct?
Yes, sir.
And it appears that there's no proof of service of your motion in order to show cause upon Michael, is that correct?
That is correct, sir.
Okay. When I first received this, I normally will set for hearing, because when these come up, I don't have time to review all of your allegations. But in preparation for today's hearing, I did review these allegations, ma'am. And I don't see anything in here. If you want another hearing date, we get another hearing date, but I don't see in your petition that there's any threats to assault you. Maybe I missed it, but you've got about 3 pages here, and you talk about soliciting you for sex, defacing you, communications with your boss. In order to, this is what I consider a bare bones PPO. It prevents him from assaulting you or threatening you with physical harm or violence. Doesn't prevent him from calling you or soliciting you for sex or anything of that nature. So I don't see the allegations in the court's opinion do not support a violation.
Okay. Well, I was told by the sheriff to get a show cause hearing.
I'm sorry?
The sheriff department is the one who told me to do a show cause hearing.
Okay, but again, they're not lawyers, they're not prosecutors. Sometimes they tell people that because they don't know what else to tell them. But I'm looking, I've read twice your allegations. He's texting you, calling him nonstop. That's not a violation of this. Now, if he's threatening you with physical harm or violence, that's different, but I don't see the allegations in here. What I would suggest is block him. The 2 of you are never married, you have no children in common, correct?
I did block him.
Okay.
No, I did. I did. I ignored everything, sir.
Yeah, just ignore him. But if in fact he's threatening you, then that's one thing. But I don't see that in these allegations. And to waste the court's time and give him a court-appointed lawyer, we're going around in circles. So I wanted to be very frank with you this afternoon, Ms. Burns.
Right.
At this point, I'm going to dismiss without prejudice. You can get another hearing date from the clerk. They give out these hearing dates and these people go down to the clerk's office. You can file another petition, but be very specific in terms of you can come in and look at the file. You probably kept a copy of your statements. I just don't see in here where he has threatened you, has assaulted you, or threatened with physical harm or violence. You talk about incidences of March 12th. Mike was texting you, freaking out. He said he got a call about an outstanding warrant. March 18th, Mike texted about the washer and dryer. I don't know when he could get them. March 20th, Mike texted that his boss were both called. I'm not sure what those allegations. I don't see how they bite this personal protection order.
He showed up at my work, sir, at my offsite, and he started fighting with my boss.
Okay, that's your
So
boss.
my boss called his boss.
Yep, your boss should get the PPO, and he should be trespassing with property. You don't want him to interfere with your employment.
Correct.
So your boss should call and have him arrested for trespassing. You don't want, again, the texting you on March 23rd, again, it's an aggravation, but that's not a violation of PPO. This does not prohibit that. And of course, so at this point in time, the court's going to deny, be without prejudice, your request for an order to show cause. I'd suggest you review and perhaps maybe clarify your fact statements. And if you feel strong enough about it, you can go to the clerk's office, file another motion for it to show cause, and we'll give you another hearing date. But please come in and review. And I don't know if you kept a copy of the statements that you attached to your PPO. Lori from Roosevelt called you, calling from Mike. She knew I would just ignore those people. The 2 of you have no children. No reason why you should have any contact. Any questions, Ms. Burns? Ms. Burns, do you have any questions?
Oh, sir, I'm sorry.
I'm sorry, you're breaking up on us.
No questions, sir.
Okay, all right. Well, all right, thank you, Ms. Burns. And again, if you come and review what your fact statement, and if something else happens, file another motion. Don't hesitate. But this time, I'm going to deny without prejudice. Okay.
Absolutely.
All right. Hopefully, he'll move on with his own life and leave you alone, Ms. Burns. All right, that will conclude this matter.
Thank you.
Welcome.
Thank you.
You're welcome.
Versus Kenneth Andrews.
For the record, this matter is before the court for continued pretrial conference subsequent to a couple of days of mediation with the mediator William Godfrey. This hearing is being conducted via Zoom. Present is Attorney Christina Hills, representing the plaintiff Ashley Andrews. Ms. Andrews appears to be present. In addition, Attorney Michael Cutler is present, representing the defendant Kenneth Andrews, and Mr. Andrews appears to be present. Good afternoon, Ms. Hills and Mr. Cutler.
Good afternoon, Your Honor.
Have the parties, Mr. Godfrey, the parties that have been, the court's informed the parties have reached their own agreement. Is that correct?
I believe that is correct, Judge.
Right, and if counsel has no objection, the court will have Mr. Godfrey stated in the record what it understands to be the parties' agreement.
No objection at all.
My client and I had been emailing back and forth about a couple of issues. I don't believe they will prevent us from putting a settlement agreement on, but I want to make sure that she and I are on the same page prior to putting this on record. If I could just have a moment with her.
Okay.
I'll put you in a breakout room in a moment.
Thank you.
How are you today, Your Honor?
Fine.
Good to hear.
Always much better to end the day when I know the parties have reached their own agreement with capable family law practitioners, a good mediator. So thank you, Mr. Cutler, for your assistance.
Well, I complimented Mr. Godfrey quite a few times. I think he did an admirable job. He remained late. He went back to the office late to have things typed up, and I received a nice summary of about 7 or 8 pages this afternoon. So I do appreciate it.
It's 10 pages.
I guessed.
And he picked up the phone at 9:10 p.m., Judge.
Of course, very well. Mr. Godfrey devotes a lot of time and attention, is well prepared for these mediations. So the court appreciates that, Mr. Godfrey.
You're welcome, Judge. I have fun doing them.
Just don't retire on me. Mr. Godfrey, I got another 6 years left.
I will not be doing them for 6 more years, Judge. I can tell you that.
I'm sorry?
I said I will not be doing them for another 6 years. So.
Sounds like something has to give. I'm not sure who.
My wife.
Your wife, I'm sure, will not be giving in. If she's anything like my wife.
You had all the Passover families at your house this year, Michael?
We had 34 people last night and about 10 the night before that. So great to see family, but my feet and back are hurting me. Even though my wife does the cooking, I move the tables, chairs, clean things up, and it's a lot of work, but it's always worth it.
And vacuum.
Well, I have one of those little robot guys, so okay. I activated him and just stayed out of his way.
Ken, you got my summary, or did you have any questions? I don't.
No, everything looked good to me. So.
All right. Okay.
Judge, I'm sorry. Could I just have Mr. Godfrey briefly? I promise this won't take long.
Okay, we got another party waiting with Miss Patrick, but we'll wait for you.
Okay, thank you.
Court is now in session. Top of page 5, Christopher Lockwood versus Tamara Kinsella.
Okay. Correct. This matter is before the court on the plaintiff's motion for custody, support, parenting time, and other relief. This hearing is being conducted via Zoom. Present is Attorney John DQ, representing the plaintiff father, Christopher Lockwood. Mr. Lockwood appears to be present with Mr. DQ. In addition, Attorney Marie Zagorski is present, representing the defendant mother, Taylor Kinsella, and Ms. Kinsella appears to be present with Ms. Zagorski. And for the record, the court would note that next parte order was entered by Judge White on April 10th, 2024, which suspended defendant mother's parenting time and granted plaintiff father legal and physical custody of the minor child. The court would agree this court would not have entered such an order. The court would have perhaps granted temporary possession, but not custody. I don't think we can change custody without any type of evidentiary hearing. In any event, the parties have conferred at length with Ms. Patrick this afternoon. The court, in the next part order, set the matter for hearing for today. The recommendation this afternoon is that, first of all, I don't know if this was an issue, but plaintiff father acknowledges paternity of the minor child. And I believe there's an acknowledgement of paternity previously signed, so I don't know if we need any testimony with respect to paternity. With respect to parenting time, the parties shall share joint legal custody of the minor child. With respect to parenting time, defendant mother will have parenting time on Tuesdays from noon until 4 p.m. on Friday on week 1. And then on week 2, she'll have parenting time Tuesday at noon till Saturday at noon. Mother's parenting time should be supervised in the presence of the defendant's grandparents. Parties will meet to exchange minor child to the Bedford Public Library. Neither party shall exercise physical or corporal punishment on the minor child. Parties will complete the SMA program. Issue of child support shall be referred to the front of the court for investigation and recommendation, with each party having 20 waiting days in which to object. Both parties will attend parenting classes. Plaintiff father will pay child support directly to defendant mother upon the front of the court recommendation being completed. I don't know if we need a commencement date for that, Ms. Patrick, for the child support.
Your Honor, what he's going to do, he's been paying $500 a month. We're going to continue that. So it should be put in the order that he's paying $500 a month directly to Ms. Kinsella.
Okay, but once, if we get a recommendation, which is different, then you'll pay the
Correct.
modified amount?
Correct.
Okay, that's the record. Finally, the president will appear back for his court for review on May 29th at 1:30. That's the recommendation. Mr. DQ, is this recommendation good with your client?
Is that agreeable, sir? Yes.
Ms. Sikorsky, is this recommendation good with your client?
Yes, Your Honor. I would just note that we are currently in week 2, so the parties will be meeting tonight at 6 o'clock, and my client will have her child until Saturday at noon.
That's correct.
Thank you. All right, Mr. Lockwood, Ms. Kinzel, can you both please raise your right hand to be sworn?
I do.
I do.
Thank you. All right, Mr. DQ, if you wanted to voir dire Mr. Lockwood regarding this recommendation and agreement, please.
Mr. Lockwood, you heard all the terms and understood the discussion that we had with Ms. Patrick and Ms. Zagorski in the breakout rooms?
Yes, I did.
Okay, and as we put it on the record here and as the judge recited it, do you want him to sign an order that states those things as becoming an order?
Yes.
Very good. I don't have any further questions.
Ms. Gorski, do you have any questions, Mr. Lockwood?
No, thank you.
Questions for Ms. Kinzel, please.
Yes. Taylor, would you please state your name for the record?
Taylor Kinzel?
You participated in these proceedings today,
Yes.
and you understand the agreement that was reached?
Yes.
You understand that you're going to exercise your parenting time at your grandparents' house until we come back to court and review this?
Yes.
Do you believe that what we've agreed to today is in Braylon's best interests
Simple answer or
at this time?
at this time, yes.
Okay, you understand this court has jurisdiction and can always modify things if it's shown that Braylon would benefit from something else. But as of today, you believe that what we're doing is in his best interests.
Yes.
Do you have any questions of me?
No.
Thank you. That's all I have, Your Honor.
Thank you. Mr. DQ, do you have any questions of Ms. Kinzel?
No, sir. Thank you.
Well, the court would like to thank Ms. Patrick for her assistance, as well as, of course, attorneys Zagorski and DQ. The court finds the agreement to be in the best interest of the minor child. The court will going to adopt the recommendation, and we'll see one back on May 29th at 1:30 for review.
Thank you, Your Honor.
Thank you.
Thank you, Mr.
All right, thank you
Gorski.
both.
Thank you, Mr. DQ.
Mr. DQ, I just want to remind you, we have a pretrial tomorrow. I believe Jones and Pepper.
Yeah, Cindy got a hold of me and sent me a text that you want us to show up tomorrow, even though we're pushing the mediation out so we can put proofs out.
Yeah, take the proofs. You just didn't hear you once, so I just wanted to remind you, Mr. Chappell, of that. Should be very quick.
Yes, sir. Unfortunately, you get to see me again tomorrow, sir.
If you want to meet Mr. Chappell and you want to come in sooner, we can always accommodate you sooner in the afternoon.
Very good. I'll check with Eric.
Thank you, Mr. DQ. All right, you can zoom out.
Thank you for the time, Your Honor.
Not a problem. I regret the interruption. We took another matter, so that worked out well.
No worries. Thank you.
Judge, could Mr. Cutler and I have just, and his client, just 1 minute in a breakout room?
Absolutely. I've got all the time you need this afternoon.
All right.
You ready to recall the case?
Yes, Judge.
Okay.
Court is recalling Ashley Andrews versus Kenneth Andrews.
Once again, this matter is before the court for continued pretrial conference subsequent to lengthy mediation with William Godfrey, who's present this afternoon, along with both parties and their attorneys, Attorney Christina Hills and Attorney Michael Cutler. Mr. Godfrey, can you please state what you understand to be the parties' agreement on the record?
Thank you, Judge. We have 3 minor children, Colin, Garrett, and Colton. The parties would share joint legal custody of their 3 minor children. Each parent would have free and open access to the school, extracurricular activities, and doctor's appointments of their children. All communication involving the minor children shall be through the app close device. When appointments are scheduled, they shall be immediately placed on the app close device. This would include medical, dental, optical, therapeutic, counseling, extracurricular activities. Any type of appointment goes there. The party that makes the appointment or schedules the event for the child or children shall make every effort possible to have the appointment or event scheduled on his or her parenting time. If for any reason a medical appointment is scheduled on the other party's parenting time and the other party is unable to take the child, the party that has parenting time at the time of the appointment shall communicate with the other parent to confirm whether he or she is available to take the child prior to the appointment being canceled. I'm trying to avoid medical appointments being canceled because the custodial parent at the time can't get the child there. Each party shall make every effort to keep all scheduled appointments. If a parent signs a child up for any non-school related activities, the other parent shall be notified of all such activities as soon as they become available, and they're certainly welcome to go if they want to go. As to parenting time, the parties would continue the current week-on, week-off parenting time arrangement that would continue during the school year. Exchanges would be Friday after school. If there is no school, the exchange will be at 4 p.m. The exchange location would be at the sheriff's station located at 12060 Montewuka Drive, Benton, Michigan, absent a contrary agreement of the parties. So after, there's a PPO out there, but after that expires, if they want to make other arrangements, they can do that in writing. Parenting time during the summer would be 2 weeks on, 2 weeks off, and that would be rotated during the summer. That rotating 2-week schedule would start with father the first Friday after father is out of school in whatever school district father is then employed with. He's a teacher. So this year, it would start on Friday, June 14th at 4 p.m. I think his last day is like the 13th, but it would be the 14th this year at 4 p.m. The Monroe County Friend of the Court holiday schedule would be utilized for all holidays that are on that schedule, absent a contrary written agreement of the parties. The children would continue in the Lake Fenton School District. The children are to be to school on time. If a child is to miss school, the reason shall be for a medical condition. The medical condition shall be verified by either a doctor's excuse note or an urgent care / hospital note. If the parent wants a child in latchkey, they may do so on their own time at their own cost. Counseling for the children would continue. The children had intake with Mr. Broughton on April 17th. Therapeutic counseling shall start immediately. Each party shall attempt to schedule the counseling, taking into account the parties' work schedules. By that, I'm trying to avoid having a counseling session during school hours or during a extracurricular activity that they're involved in at school. So we're trying to coordinate that so that the counseling would all be conducted after school hours and without interfering with their activities, the children's activities. The minor children's therapist shall determine if in-person or telehealth appointments are appropriate. I indicated I would prefer inpatient or in-person. Minor child Garrett would continue with his therapist, Melanie Tamalia. That counseling would be in person unless the therapist indicated that it could be via an alternate method. The children would continue to be treated by their routine pediatrician, Dr. Vorbach. As to extracurricular activities, if it is agreed to, then the parties shall share that cost.
Hold on a second. I see. There it is. I thought we lost Ken for a moment. Okay,
right.
Thank you. Apologize. Go ahead.
I'll go back. Extracurricular activities, if it is agreed to, then the parties shall share that cost 50-50. Currently, the children are involved in various children, but wrestling, track, band, and basketball. Each child is involved in some combination of those activities, and those activities would continue for the children. If there is any traveling non-school extracurricular activity that a child is involved in, the parent that wanted the child to be in that extracurricular traveling activity shall be solely responsible for its cost unless the other party agreed to the same. For example, one child is in traveling wrestling. If father wants to have that continued, he would be responsible for that traveling extracurricular activity cost. Mother need not do it unless she agreed to. Mother indicated that she does not oppose to the children being in the traveling wrestling, but it would be father responsible for paying of it. So I think we got maybe traveling baseball this summer too. That would fall under the same thought process. Both parties had a laundry list of expenses that they had paid for the children since the divorce action started. Each party would not be entitled to any reimbursement for any portion of those costs that have been incurred prior to the entry of the judgment of divorce. All of those claims or requests for reimbursements have been taken into account in the global settlement of the case. Health insurance for the minor children would be by father. He would continue to maintain that, and that would continue so long as it's available at a reasonable cost through his place of employment. Reasonable cost is defined as 6% of father's gross income. When father has the insurance coverage, mother need not obtain it. For purposes of running the child support guidelines, I calculated father's costs to cover the minor children at $120 per month. Any uninsured medical expense would be split by the parties, with father paying 70% and mother 30%, after mother pays the first $454 per child per year of uninsured medical expense. There were issues concerning the HSA account that father has created. There is currently $698.17 of medical expenses that mother claims she had paid out of pocket. Those expenses shall be reimbursed out of the SHA account to mother. So mother just needs to submit them, and that has to be repaid to mother. All other sums in the HSA account shall be held for payment of future medical expenses of the minor children. All claims for disbursement or allocation of the HSA 50-50 between the parties is not occurring. Whatever is there is going to be used for the kids. If husband wants to contribute additional sums going forward to the HSA account, he could do so, and those funds could be allocated either between the children and himself, or both, or any combination as father deems appropriate. I'm just locking in the HSA account now. Whatever is there would be used for the kids, and how that's funded in the future is going to be up to dad if he wants to put it in for the kids or kids of himself, or no one. He's not bound by that.
Mr. Godfrey, can I interrupt?
Child support. Father shall pay child support to mother commencing May 1st of 2023 as follows. I have the breakdown in my letter, but for 3 children, it's $506, 2 children, $356, 1 child, $213. This would be part of a uniform child support order. That would all be through the friend of the court. There are no arrearages or claims for unpaid expenses carried forward in the judgment. I provided a copy of the child support calculations with my summary letter, and they can use that or provide that to the friend of the court if there's any future request for recalculation. As to tax allocation of the children, when there are 3 children to claim, mother would claim the extra child in even years and father in odd. When there are 2 children to claim, each party would claim 1. When there's 1 child to claim, mother would claim in even years and father in odd. The allocation of the child exemption would be part of the child support provision of the judgment of divorce, and therefore subject to modification by the court. Father claimed children Colin and Colton on his married but separate 2023 tax return, so mother would be claiming Garrett. Those are matters involving the children. Any questions by the parties or attorneys dealing with children issues?
I have one question, just a clarification regarding the HSA. So after the $698.17 is reimbursed based on the billing statements that my client would provide to Mr. Andrews.
I think she would provide those right to the HSA.
Okay, then she'll provide those to the HSA. Those would be reimbursed. Then any residual funds in the HSA would then be used for bills for the children before her $454 requirement would kick in?
Yes.
Okay, thank you. That was my question.
So we're just going to use up what is there.
I just actually refunded it $4,000. I wouldn't have put that much in. I put way more than what I needed to cover myself, and I'm not okay with that. So
Then you probably should withdraw your $4,000 if you can, or talk to somebody there.
Or withdraw the 1,000 and leave enough to cover the $698.17.
Yep. I'll talk to you about it afterwards, Ken. If you can do it. I'm
Okay.
not so familiar with HSA, but we'll try to work through it.
I'm pretty sure I don't think you can do it. So, but okay.
Anything else? All right.
No.
I go to real estate. The parties have an interest in a number of different parcels of real estate. I will go through each one separately. 12600 Porter Street, Carlton, Michigan was sold on land contract. The balance of that land contract is approximately $58,000. That would be paid off approximately on or about June 1st of 2030. All payments on the land contract are being paid to Andrews Properties Holding Company, LLC. The net proceeds would be divided 50-50 between the parties. So once it goes into that, they can split that after there's some other expenses that are coming out of that, but they would split that. When the property was sold, there was a payoff resulting in each party receiving $42,963.15. Those funds were being held by the parties' respective attorneys husband's or father's was being held by a prior attorney, not by Mr. Coulter. Ashley's were being held by Ms. Hills. Those funds can now be released, and they would be going to the individual parties. Ashley would get hers from her attorney. Ken would get his from his attorney. Whatever is left after attorney fees have been compensated or allocated. 713 Fenton Road, Flint, Michigan. This was also sold on land contract. The land contract balance is approximately $45,500. This would be paid off in October of 2025. Those payments are also made to the same LLC, Andrews Properties Holding Company. The net proceeds there would also be divided 50-50 between the parties. As to each of the land contract payments going into the LLC, the parties would have to pick up half of the income or half of the expenses on their individual return. They're solely responsible for payment of half of the tax liability on whatever they get. So if there's the liabilities that they're paying for, let's say, a CPA of $500, those $250 are allocated to each of them. And if there's income of $5,000, they each share half of that income. The last parcel of real estate is 836 Simcoe, SIMCOE, in Flint, Michigan, 48507. That property was quitclaimed from Andrews Properties Holding Company, LLC, to Andrews 5, LLC. Andrews 5, LLC is a corporation owned by husband's father. There was discussion concerning funds that were still owed by the Andrews Properties Holding Company, LLC. That debt was approximately $9,710.53. It will be up to Andrews 5, LLC to determine if that entity wants to sue for the $9,710.53 that may be owed. If there is any judgment entered or negotiated settlement of that debt, that would be paid out of the Andrews Properties Holding Company, LLC, from the funds that are being paid to that LLC pursuant to the two land contracts that I just discussed. Any questions on the real estate?
None.
No, thank you.
All right, business interests. We have a number of LLCs, and I'll run through those. Andrews Holding Company, LLC, that is owned by the parties 50-50. That is, it should be Andrews Properties Holding Company. I didn't catch that before. This is where the land contract payments are going for those two properties sold on land contract. That is staying open. As I previously indicated, any income tax is shared equally by the parties. Andrews Properties Industrial Company, LLC, that business is awarded to wife. She shall receive that property free and clear of any claim, title, or interest of husband. Wife shall be solely responsible for any indebtedness related to this corporation, and she shall hold husband harmless from any liability thereon. Andrews Property Services, LLC, this business is awarded to husband, free and clear of any claim, title, or interest of wife. Husband shall hold wife harmless from any liabilities concerning this business. Sold by Andrews, LLC, is a corporation awarded to wife, free and clear of any claim, title, or interest of husband, and wife shall hold husband harmless from any liability concerning that corporation. The parties had created Canopy Farms, LLC, that is defunct now, although it isn't defunct on the state website. The parties believe that this company has no assets and will just let that one die. I told the parties that the federal government is requiring a disclosure that has to be done by the end of the year. They need to agree who is going to go online with the federal government and put that disclosure notice on there, but they've got to figure that out. They'll have to do that for their own LLCs. Any questions dealing with business interests?
No, thank you.
No.
Right. Automobiles and other specific items that we've allocated. Wife is to receive the 2021 Chevy Tahoe, the 2001 Lawson boat trailer and Mercury engine, and a utility trailer. Husband is to receive the 2021 Buick Enclave, 1984 Monte Carlo jet boat, hot tub, and a riding lawnmower. Each receives their items free and clear of any claim, title, or interest of the other party. Each party shall hold the other party harmless from any liability on any of the items that they have been awarded. Parties have an interest in a Heartland camper. The camper is underwater. It is subject to foreclosure. It would take $2,880 to get it out of foreclosure. If a party wanted to pay that to get it out of foreclosure, they could. And any deficiency, including any cost to get it out of foreclosure, when it is sold, would be split by the parties 50-50. Husband does not want to have anything to do with trying to sell it, but if wife wants to sell it, she can. And she would have until July 22nd of 2024 to do that. I don't think she wants to, but in any event, any deficiency is split 50-50 by the parties. As to all of the vehicles being allocated, if there's any titles to be signed, they needs to be signed forthwith so that they are transferred to the appropriate party. Each party is to get their own insurance on the items that they have been awarded. As to bank accounts, there are some bank accounts that the children have in their name. Those would be held or managed by the parent whose name is on that with the child. There were a number of other accounts that were created during the marriage. They have been separated. Each party keeps whatever bank account that they may have in their name, free and clear of any claim, title, or interest of the other party. Any request for an accounting or allocation of funds in the accounts have been eliminated by this agreement. Retirement, wife does not have any retirement. Husband has, I believe, 3 retirements that I identified as a MERS pension with the state of Michigan, a 403B or a 401K, DRVFIF, and a Roth IRA. Those are all marital. Those would all be divided 50-50 by the parties using a valuation date of December 31st of 2023. Any gain or loss from that date is allocated to each party's share. Wife is not entitled to any contribution that husband may have made since the December 31st of 2023 date. All quadros that would need to be prepared would be prepared by Ms. Attorney Ann Pastrana, absent a contrary agreement of the parties, and I have her contact letter or information in my letter to the parties. Any cost for Ms. Pastrana and or the plan administrator to implement the quadros would be shared equally by the parties. The division on the pension would include anything purchased years during the marriage. So I believe there was some years purchased, but it includes everything that is there would be divided 50-50. For purposes of the pension, it's mandatory, but wife is the surviving spouse on the pension. As to life insurance, each party would keep whatever life insurance that they may have, free and clear of any claim, title, or interest of the other party. Each party is free to name whomever they desired as a beneficiary on their own policy. As to marital debt, each party keeps their own debt. Wife has a slew of debts. Credit cards, I've identified those. Husband has his. I totaled those up and they were quite significant, but each pays their own. There should be no joint credit cards out there. So if there's a card where that his husband is keeping and wife was a permitted user, that should be done with. Likewise, if there is any cards that husband may have been a permitted user, those need to be eliminated as well. The only other debt was the Eagles Cove lot rent. That is where the trailer had been. And that is to be paid equally by the parties. And that would cover the camper at the site through April 30th. And wife, or if they don't, they need to, is anybody moving that or is this going to be repoed from the site? I guess it doesn't matter. The lot rent is just through April 30th and they're not going to pay for after April 30th. That $100 or $1,200 should be paid. Whoever pays that, the other party needs to be reimbursed within 30 days of the judgment of divorce if somebody is paying that. If not, they share it 50-50. I talked about the money that might be owed to Andrews 5 LLC, and that I discussed under the real estate section. The 2023 taxes, they're filing married but separate. Husband claims 2 children in 2023, and I already indicated that. Wife would claim 1. In 2024, wife would claim 2 and husband 1, and they keep going back and forth when they have the 3. Each party would keep whatever refund or be solely responsible for any liability on their own return. Health insurance, each party is responsible for obtaining their own health insurance coverage at their own expense post-divorce. I didn't have this in the letter, but if either party had incurred any medical procedure that was not covered by insurance, each party is responsible for payment of their own uninsured medical expense. As to maiden name, wife would have restored to her maiden name of Ashley Elizabeth Moen, M-O-E-N, if she so desires. Each party should be responsible for payment of their own attorney fees and cost. Spousal support for husband is forever barred. Spousal support for wife is granted. Husband shall pay to wife spousal support in the amount of $230 per month for a period of 48 months, commencing May 1st of 2024. The spousal support is non-modifiable, terminates upon the death of either party, remarriage of wife, or 48 months, whichever occurs first. A uniform spousal support order shall enter. The spousal support shall be paid through the friend of the court. Personal property, each party keeps whatever personal property items that they may have in their possession, free and clear of any claim, title, or interest of the other party, with the exception of the following. Husband shall release to wife a leather ottoman, as well as a percolator and large glass jug dispenser if those 2 items are found. There was discussion concerning 3 curved TV monitor screens. Husband claims that there were 3 had been purchased. Wife claims that there was only 1 screen, and that screen is in her possession. It will be husband's responsibility to establish by clear and convincing evidence that there were 3 screens purchased. If there are 3 screens purchased, each party shall be entitled to 1. I don't know where they're at, but they each get 1. The 3rd screen would be divided between the parties, with each party bidding on the screen. The highest bidder would be awarded the screen. The bidding would be in increments of $10. If there is only 1 screen, or husband cannot prove that 3 screens were purchased, the 1 screen would remain in wife's possession. I didn't put in here, and maybe we have to pause for a moment, but if there are proof that there are 3 screens and we cannot locate 2 screens, then husband is compensated for 1 screen and half of the other screen. I can arbitrate that as to price if the parties so desire.
Do so desire. Thank you.
All right. There was an issue concerning dog Xylo. Wife indicated that she no longer had the dog. That dog is now owned by her father, Tom Moen. If the dog is not returned to husband, then the parties shall determine the value of the dog. If there is a dispute as to the value of the dog, that would be decided by me acting as an arbitrator. The value of the dog would be split 50-50 between the parties, with wife paying husband for his half interest. If the dog is returned, it would be awarded to husband. The arbitration on that issue and on the screen issue would be binding arbitration, which means the court has no control. The sole role of the court would be to enforce the award of the arbitrator, and the parties would have no recourse going back to court to litigate the 2 screens and the dog value. Any questions on the personal property with those slight revisions that I just talked about?
No, thank you.
Ashley, any questions?
No.
Ken?
Good.
All right, thank you. Car insurance, husband shall reimburse wife $1,189.42 for car insurance. That should be done within 30 days of the entry of the judgment of divorce. We had cell phones. Wife's request for reimbursement on the cell phones that were utilized by the 3 children was denied. It's done. If parties want the kids to have cell phones and they cannot cooperate as to getting a phone for the children and share that cost, then if dad wants the kids to have a phone at mom's, he gets kids and pays for the phones and they can take them to mom's. If mom wants phones at dad's, mom can buy the phones and have the kids take the phones to dad's house. Each party would then pay for their own phones. Neither party can block the access of of the use of phones at the other parent's house. So if dad gets phones and they go to mom's, they're not to be blocked. If mom gets phones for the kids and go to dad's, they can't be blocked.
Excellent.
Personal liberties. There should be generic language placed in the judgment dealing with mutual injunction against personal liberties. Neither party shall interfere with the other party's personal liberties. There shouldn't be any stalking, tracing, following. They need to be done. There also shall be a prohibition in the judgment about disparaging remarks. There should be none of that. There also is a prohibition that neither party shall disseminate any intimate pictures or recordings of any type that the parties may have created, whether it was voluntary or involuntary, but whatever intimate pictures are out there, they're not to be disseminated. There's no exceptions to that. If there is a Flint water settlement dealing with any of the real estate or corporate entities that I've discussed in this settlement, any sums paid would be split 50-50 between the parties. So if anything is paid to the LLCs or anything paid for any of the real estates, those are all split 50-50 if there ever is a payment. An anti-bankruptcy clause would go in the judgment. If the parties have a dispute as to the language in the judgment, that would be referred to me for final decisions concerning the language. I hope I wouldn't have to get into that, but rather than have to file motions and everything, I'm willing to just figure that one out. This resolves all the matters that are pending between the parties, including any matters that were reserved under prior orders, or any scheduled court hearings, or any motions that are currently filed or pending. Everything has been taken care of. No matters are preserved or carried forward in the judgment unless specifically indicated or stated in the settlement agreement. That's it, Judge.
Thank you, Mr. Godfrey. Ms. Sills, did Mr. Godfrey accurately state your client's agreement?
Yes, Your Honor.
Mr. Cutler, did Mr. Godfrey accurately state your client's agreement?
He did, and I do want to just identify from what Mr. Godfrey read from, that's his correspondence dated yesterday, April 23rd, 2024. I think he essentially restated it word by word or pretty close to it. So it is an accurate rendition.
Thank you. Mr. Andrews, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. The court would note to Ms. Sills the proofs were taken back on July 19th. We can simply update the proofs by confirming with Ms. Andrews that she's not now pregnant. Then you can voir dire her with respect to the agreement, please.
Yes, Your Honor. Ms. Andrews, would you state your name for the record, please?
Ashley Elizabeth Andrews.
And the court had inquired of you previously at a prior court hearing as to whether you were pregnant. You'd answered in the negative at that time. Are you pregnant today?
I am not.
All right.
Thank you.
Have you heard the settlement agreement, which was placed on the record by Mr. Godfrey and with Mr. Cutler and myself asking some questions along the way?
I have.
And do you understand all of the terms of that settlement agreement?
I do.
Do you have any questions about it as you sit there today?
I do not.
Have you had enough time to think through all of these issues?
Plenty.
Right? You arrived at the settlement agreement as a result of a long mediation process in which you participated. Is that correct?
That is correct.
Right. And you reached an agreement as stated by Mr. Godfrey regarding spousal support or alimony, we also call it. Is that correct?
Yes.
You understand that spousal support as to Mr. Andrews is barred forever, meaning he could never come into court and ask for it in the future.
I understand.
You are being awarded non-modifiable spousal support. You understand that non-modifiable means that neither you nor Mr. Andrews would be able to come into court and ask that the duration or amount be lengthened, shortened, increased, or decreased.
I do understand.
All right. And you understand if we had gone to trial and the court had made the decision regarding spousal support, that would have been fully modifiable.
I understand.
Right. You understand we could have had a trial if you had wanted one. We could have presented all of this evidence to the court and let the judge make all of the decisions for you.
I understand.
By entering into the settlement agreement, do you understand you're waiving that right to a trial?
I do.
You've also agreed regarding certain personal property issues to a binding arbitration with Mr. Godfrey, correct?
Yep.
And do you understand that with binding arbitration, then Mr. Godfrey would be acting as the sole decision maker? You would have no recourse to the court on those issues other than for enforcement purposes.
I understand.
And you're willing to agree to that?
I agree.
Right? Have you disclosed all of your assets and liabilities during the course of discovery and negotiations in this case?
I have.
Are you satisfied with my services on your behalf?
I am.
Are you asking the court to adopt the settlement agreement, incorporate it into your judgment of divorce, and grant you a divorce once the paperwork catches up?
Please and yes.
Okay, thank you. I have nothing further.
Thank you, Ms. Sills. Mr. Cutler, do you have any questions, first of all, for Ms. Andrews?
I do not. Thank you, Your Honor.
Questions for Mr. Andrews, please.
Yes, Mr. Andrews, can you hear me?
Yes.
Okay, I'm going to ask you some questions. This has been a very lengthy process for everyone involved. You went through 2 prior mediation process and then a 8-hour session with Mr. Godfrey, reaching that resolution that was dictated and described in his correspondence on April 23rd, correct?
Correct.
You've been involved in the entire process from beginning through today's date, correct?
Correct.
I sent you a copy of Mr. Godfrey's correspondence. You reviewed it. You indicated to me that that was an accurate representation of the agreement as you recalled and by your notes. And we've sort of tweaked a few little things today, which you further expressed an agreement as little things placed on the record. Is that accurate?
Correct. That is accurate.
You understood you could have gone to trial. You could have decided not to accept the proposal or any portion of it, and you could have asked the matter to be resolved by the court, present witnesses, documents, present your proofs, arguments on your behalf, and allow the court to make a ruling upon those issues. You understand that?
I do.
You've decided to forego those opportunities, to waive those rights, to be bound by the terms that were expressed by the court, by Mr. Gottfried upon the record.
That is correct.
I've described all the situations to you regarding spousal support, modifiable, non-modifiable, all the very nuances of the issues involved. You have a full understanding of this agreement?
Yes, I do.
Okay. And you wish the court to adopt that agreement once it's in written format, expressing it in what's known as the judgment divorce, expressing all of these terms. You're asking the court to adopt it, to sign its name to the judgment, at which time you will be divorced.
Sounds excellent.
Do you have any other questions of me, sir?
I do not. You guys have done an excellent job to resolve this issue.
Okay. And do you have any questions either to the mediator who's here, who gave the presentation, Mr. Godfrey, or to the court? Are there any issues at all in your mind that you need to have to bring the court's attention?
I just would wish that the dog would be returned to the rightful family so the kids can enjoy it, whatever amount of the family that is actually left. I would appreciate that.
I understand that. And then I've just lost the dog, so I understand your feelings in that regard. But there are terms relating to the dog, and you're willing to be bound by those terms.
That is correct. I just want to make sure it was stated.
Understood. I have nothing further, Your Honor.
Thank you, Mr. Cutler. Ms. Hills, do you have any questions of Mr. Andrews?
Just briefly, Mr. Andrews, during the course of negotiations and discovery in this matter, have you disclosed all of your assets and liabilities?
Yes, I have.
Thank you. Nothing further.
Ms. Hills, you'll prepare the judgment?
Yes, Your Honor.
Thank you. Very well. The court would like to acknowledge Mr. Godfrey for his fine assistance and time spent helping these parties reach their own agreement. The court would also like to acknowledge Attorney Hills and Cutler for helping to facilitate an amicable resolution. Mr. and Ms. Andrews, without question, the best resolution of this matter is one in which you both participate, as you have. I assure you that, rather than throwing things up there and have this court sort them out. Keep in mind you're tied together for life because of your 3 children. And I just urge you, keep it. There's enough challenges in life. Keep things good for the children. Be respectful of the other parents in the eyes of the children. They're old enough to sense when there's tension, animosity, and try to minimize that and make it life good for each other and the children from this point forward as you move forward. Based on the testimony, however, that's been presented this afternoon, as well as previously in the complaint filed this matter, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. Unfortunately, it appears that there's no reasonable chance of reconciliation. Accordingly, upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter granting a divorce from bonds of matrimony. Good luck to both of you. Thank you again, Mr. Godfrey, Ms. Sills, Mr. Cutler. Can all zoom out?
Your Honor, does the court want to set a control date just to make sure the paperwork comes in whatever the time frame the court wishes, or is that not necessary?
Not necessary. We have our own internal control date. So
okay.
So when the court's confident that Ms. Sills will get it prepared and submitted. So thank you, though.
Thank you.
You can all zoom out. Have a good rest of the evening.
Thanks, Judge.
Thanks, Your Honor.
Thanks, Bill. We appreciate it.
Welcome.